much indeed, Jim. That was a very generous welcome. Very kind of you indeed. We live in a new world. We live at a time of great challenge, of great opportunity, and of great hope, but also at a time of very considerable political and social uncertainty, political, economic, and social instability. We have just lived through the most devastating crisis in 80 years, if not longer. Economies have been ravaged by recession, credit and lending, contraction, faltering demand, austerity, and in the worst cases, loss of personal employment and housing foreclosure. This has been a devastating event in terms of political, business, community, family, and individual terms. We need to create a new model, a new market system, a new regulatory and supervisory structure, and a more resilient infrastructure. We need to create a new social and market future. One possible solution, one possible new direction, one possible new stimulus, new start, may come from the most recent very significant advances in financial technology and FinTech, and associated regulatory technology, RegTech, and regulatory practice. A new financial landscape has been created within a very short period of time, characterized by social media and continuous real-time information exchange. The personalization, mobilization, digitalization, disintermediation, and democratization of financial services. We also have the decentralization and distribution of financial activities and software systems across networks, and the fragmentation of older legacy business models across the banking and financial area and across countries and across the world. This has resulted in a new atmosphere, a new environment, a new culture, and a new condition of choice, democracy, and inclusion, rather than protected elites, privilege, and exclusion. Frustration and dependence have been replaced by a new call for freedom and opportunity. Technological and market advance may now generate further and more effective political, social change, growth, and development. We are at the beginning of something very exciting with financial technology. Now, a lot of you have covered a lot of this before and know all the basics, so I don't want to waste too much time on the core material. We'll look at financial technology, focusing on financial technology law. What is FinTech? We have unicorns, decacorns, zombies, we have fangs, beggars, misfits, and bants. I'm sure all of you know all of this. Fangs, Facebook, Amazon, Apple, Netflix, and Google. Beggars, Box, Etsy, and GoPro. Misfits, Match, Fixbit, Twitter, and Alipay, and Square. The bants are the Chinese, Baidu, Alibaba, NetEase, and Tencent. The world is going to be taken over by, on the West, the large tech companies, Apple, Google, Amazon, and then it's going to be Alibaba, Baidu, and WeChat in the East. And we're going to see how that actually develops. There's a number of exciting developments here, but there's also a number of significant warnings, a number of issues we have to watch. I won't spend too much time on the basics, as I've said, just a couple of things to highlight. These are all in the core slides. What I want to do is go on to the law slides. What is financial technology? A lot of people define it in terms of financial solutions. I don't know what the solutions are, so I define it in terms of financial function. Disruption. A lot of people talk about this in terms of disruption. Disruption is just a form of aggravated change. As I see it, what's actually going to happen is we're going to have competition, cooperation, product assimilation, platform absorption, and simple company acquisition. There is going to be fundamental change. I'm not sure how much of it we can attribute to disruption as such. FinTech history. We have FinTech 1, 2, 3, 4, 5. We can tie that in with the history of money as well. Money, revolution, infotech, finance, and economics have all gone through rapid change, rapid development in recent years. There's a number of slides on market size. London is still the top, it's still the center, and hopefully it will stay that way. Clearly, the implications of the UK withdrawal from the EU has to be taken into account, and we just have to watch how this comes around. We have a number of very important UK reports. We have a number of important international reports. We have a number of important EU reports. What will FinTech affect? FinTech will affect everything. Banking, securities, insurance, and all the sub-areas within that. Everything will be impacted in some way. These are just some diagrams and some of the key changes, some of the new platforms, which we will be covering in our platform report. I'll come back to FinTech risk. Clearly, we have the traditional financial risks, the operational risks, the legals, conduct and management risk, and environmental. What is financial technology? It's technology risk. What is that? It's a form of operational risk. Specifically, in terms of technology, we can look at model or design risk, we can look at component risk, we can look at software risk, we can look at network or connection risk, and then we can look at aggregate or systemic risk. But we're also in this area going to have another important sub-areas of risk. A whole series of new information risks are going to arise. Record and archive risks and other forms of advanced technological risk, which we're only beginning to look at, and that's some of the work that I've been looking at. I won't waste time on digital currencies and Bitcoin. Nicolas is going to take you through all of that. Bitcoin history is all in the slides if you're interested, and Bitcoin technicals. And we'll come back to that separately. I've also been working on a sort of map to try and compare advantages and disadvantages. It's on the slides that you've got, which I can use both for FinTech more generally, as well as in connection with more specific aspects of the new technological and platform development. I look at this in terms of technology, business models, user and stakeholder interest, globalization and regulation. Within this, I've come up with 5 advantages within each one of those, so the basic template is 5 by 5, 25. I then do the same with disadvantage, although in this case I also had to include infrastructure points, monetary policy and central banking, as well as financial stability. So I've essentially come up provisionally with 25 arguments for, 40 arguments against. But that's not to say this isn't going to work and to be negative in any way. It simply means these are points of exposure, points of challenge, points of interest, points of concern that we need to deal with. And if we solve them, everything will come together. Now, what I want to do is focus on financial technology law. This is what I've been working on. I'm trying to write a book just now. 8 main sections, 8 main chapters. They're all coming out 30, 40,000 words each, looking at the historical development of money and financial technology, looking at the new financial technology markets. That's already in a pre-publication phase. I published one version of it and I'm now doing an update version. That's available on the system if anybody would like to read it. I've also been working with the Bank of England on a new paper on financial technology law, which is this one. It's already 40,000 words. It took me 2.5 months, and would you believe I wrote the whole thing on a phone? That is technology. That is technology. I'm also working on a separate paper on private digital coins, Bitcoin, and all the other 675 others, as well as the new 350 more recent ones that we're covering in our report, over 1,000 private coins. I'm also doing a separate paper on infrastructure and digital payment systems, another paper on regulation and financial technology, RegTech, and then final paper is looking to the future. My chapter 1 starts by looking at the last 5,000 years. What I'm trying to do in chapter 8 is look at the next 5,000 years. And I've got a full draft. It's already 25,000 words trying to explain the future of humanity in terms of technology. Now, just in terms of the law, we don't have an enormous amount of time, so let me just focus on some key issues. The first key point simply is this. We're creating all these new digital societies, digital systems, all based on digital information. But the point simply is this. What is information in law? Now, I thought what will happen is I'll go and get an information technology book, an intellectual property book, or some other form of book, and someone will have considered this and looked at it and come up with the answer. But I couldn't find anything on this. We do not know what information is in law. So what I thought was, well, it's not just information. What is data? What is knowledge? What are ideas? And then what are records and archives? So what I've had to do to begin with, to start my own writing on this financial technology law, chapter 3, is basically try to come up with a whole series of my own definitions from start on. So what is law? Law is any fact, statement of fact, opinion, or law. That is information. What is information? Any statement of fact, opinion, or law. What is data? Data is controlled or structured information that's been collected within a series of predefined perimeters or sort of controls. What you do is this: when you create data, personal data, you're filling out information questions, information boxes on a digital system. So it's structured information, it's controlled information. That's data. What is knowledge? Knowledge is essentially understood or appreciated information, then used or applied to secure a particular policy purpose. So data is then essentially processed or applied information. Sorry, data is structured or controlled information. Knowledge is processed or applied information. What are ideas? Ideas are simple representations of mental representations of information. And then what are records or archives? Those are permanent, immutable, stable records of information that we keep longer term. So initially, we have to define information. But then the next question that arises is, what is information? Is information property or is information not property? Now, there's a lot of writing in this area, most of it done by very intelligent lawyers, common lawyers, basically in the area of secrecy and confidentiality. And there's a large number of cases that basically indicate that information should be property. But there's also an equally large number of cases that say information is not property. My own opinion is that information is not property and information cannot be property. And if we look at the case law, I think we can distinguish all of the cases which do suggest this or indicate this, but I think what's happening is this. The judges are using a property analysis by way of metaphor, simplification, example. I think if we actually look at it in any detail, information is not property. But still, the question then arises, do we need to protect it? Is information an asset? Yes. Is it a commercial asset? Of course. We've already identified 6 of the largest, most powerful, fastest growing companies in the world. And what is their sole asset? Their sole asset is personal data. Personal data is the new gold. So it's not property, but it is certainly an asset. Does it require legal protection? Yes, it does. And what I found out, what I discovered, not having looked at any of this before, there's basically 4 key areas in which we protect information, 4 different perspectives that we apply. We have private information, confidentiality, secrecy, as well as data privacy. That's a form of negative private information. That's what data protection is concerned with. The Data Protection Act, the Data Protection Regulation, the directive, the first one in '85, and now the new General Data Protection Regulation to come into effect on the 25th of May next year. This is going to fundamentally change information, because what it's doing is this, it's giving people control over their information. It's giving people the right to transfer that information. It's giving people the right to sell that information. And that's also associated with related developments in the area of PSD2, the Payment Services Directive 2, as well as in connection with what's called open banking and mobile account portability. And what's going to happen is this. Traditionally, a bank is something that held proprietary information, customer account data. That's going to completely transform, because the banks aren't going to own this anymore. Customers are going to own it, and they're going to use it and sell it and distribute it in any way that they like. And this is going to fundamentally change the nature of the banking industry going forward. Now, we also have the right to public information and data disclosure through the Freedom of Information Act, so that's positive and public. We also have intellectual property protection in the area of IP law. What is the difference between information there? It's the fact that we've added some form of additional creative element. Now, what's also happening is we're extending this, and we now have some property rights attached to data protection in the form of databases. So that's an additional sort of protective, creative extension of the creative element within intellectual property rights. But also, having looked at all of this, what I then realized was, and it picks up a point that was made earlier, we actually have to be very careful with this, because we have to consider innovation, competition, and social balance. And I became very concerned about this, and I realized with the research I was doing that a number of other writers have also picked up on this. People like Peter Drahos at our university, people like James Boyle, who's a Scottish philosopher, who writes about what he calls the commons, the information commons. What's going to happen is this. If we make creative protection, and if we provide too much protection, especially through intellectual property rights, what we're going to do is completely prohibit innovation and communication and innovation. And we're going to create a new form of what Peter Drahos refers to as information feudalism. information, I'll call information colonialism, information or technological servitude. We have to be very careful with this. There's companies, we actually refer to them as information technology, intellectual property trolls, and they actually go around the world buying up IP rights, just so that they can sell them back to major tech companies as well as governments. This is an important area, this is an exciting area. We have to protect information in a number of particular areas. We have to award protections for patent rights, copyright, trademarks, and other forms of additive activity, but we have to be very careful we do not go too far. And a number of people would argue that in America it is too easy to obtain a patent, and they've just recently extended the copyright protections further again. And this is going to be a major problem going forward. If the whole of the new world that we're creating, all of these new data societies, digital societies, information societies that we're working on, if we can't communicate, and if we can't talk, and we can't innovate, we can't do anything, simply because a small number of tech companies or these other trolls control all the information and data, how can we go forward? So this is an important social point, it's an important political point that we need to look out for. Now, we need to then go on to not just information, but digital property. And again, this is very interesting, really quite difficult. We have legal rights. What are legal rights? What are digital rights? What is property? Basically, a legal right, I've had to define this myself as well, is any interest or entitlement recognized and subject to protection under law. But then what is a digital right? Well, a digital right is a legal right created or recorded in a digital form. But the question then is, how do we classify digital rights? Are they property or are they obligations? And again, we then get into some very difficult issues. We have the whole area of English property law, and within that we distinguish land and movable property. Within movable property, we distinguish between what we call shows in possession and shows in action. And then we have a large number of cases that say there's nothing else in between. Shows in possession, shows in action. Shows in possession is something you hold, it has to be physical, you possess it. A shows in action is technically a claim. It's a claim against somebody. The most common example is a debt. But the question is this: what are all the new digital rights and digital property interests we're creating? Are they shows in possession or are they shows in action? And remember, the courts have said there is nothing in between. There is no third form of property under English law. Well, we can't hold them, we can't own them, we can't feel them, so they're intangible, and also they're not a claim against anybody. They're created by computer code. So they're not a shows in action either. Now this actually causes a lot of problems under English law. The whole point is this: the world is worth, let's say, the latest estimate is $216 trillion. More realistically, it's about $225 trillion. That's a quarter of a quadrillion dollars. If we transfer all of the existing security systems, mortgage systems, car systems, shipping systems, all of the ledgers, all of the asset record systems that we have just now, and we convert them into a digital form, how do we classify them under all of the most commonly used law systems? The answer is we can't. Scots law can deal with this because it has intangible movable property, but very other few systems have this. The Germans can't deal with it, Japanese can't deal with it because their law is based on German law. English law can't deal with it for the reasons I've been looking at. I spent a bit of time researching this, and what actually happens is, within this concept of shows in action, we can actually include real rights, real property rights, but it's actually quite unsatisfactory. Because what happens under modern English law is that under this classification of shows in action of claims, we have to put a whole series of residual rights, like leases, all of the area of intellectual property, and a large number of other asset classes. So what's going to happen is that technically, theoretically, legally, we actually have to include all of these new digital rights we're creating, all of these new digital assets, as shows in action, which is completely unsatisfactory going forward. And I'll come on to a couple of solutions in a couple of minutes. Connection with this, I actually looked at the definition of property under English law. There's some famous case law. There's Lord Wilberforce in National Provincial Bank and Ainsworth, 1965. There's Lady Hale in an important case called OBC versus Allen in 2008. And what I did was this, looking at their judgments, I've extracted what I think are 5 conditions for whether something is property, and then also 5 additional, what I'm going to call title rights. What are the rights of function that attach to property once you've identified property? So in terms of defining property, and I'm basically rewriting English property law for this purpose, 5 conditions. It has to be identifiable, so identification. 2, separation. You have to be able to separate it. 3, you have to be able to transfer it separately to a third party. 4, it has to be permanent, has to be stable. And then fifthly, my 5th condition I'm going to refer to as attachment or attachability. We have to be able to then attach these property rights, or what I'm going to call title rights, to them. Now, what are the title rights I'm talking about? If you have property, if I pick this up, if I pick anything else up, what have I the right to do to it? Well, either I can hold it or use it, 1. I can encumber or charge it by way of security. I can bequest it in a will, or it would pass through intestate succession. I can transfer it by gift or sale, and I can cancel or destroy it. So if you can do those 5 things to something, hold or use, encumber, bequest, transfer, cancel or destroy, and that thing is identifiable, separable, transferable, and permanent, and you can attach those rights to it, I will call it property. So I'm rewriting the law of English property. Now, the question then is, a digital coin, or a digital smart right, or any other digital asset that we've created on a ledger, can we do that with all of those? I would say yes. In almost any form. And then I was thinking about, can I come up with a new definition for digital assets held on ledgers? And what I came up with is this. I think a digital coin, and then any other asset that we hold on a ledger, I'm going to define it in terms of a digital data point or a digital data entry. Now, why a data point? It's digital because it's recorded in a digital form. It's data because it's controlled and structured, as we said, from our original definitions. But I also like this idea of a point. A point in time clarifies, connotes the idea of it's something that's moving along the ledger on the blockchain. To give you a very specific example, which we haven't come across yet, but I'm sure we'll come on to later. When you move Bitcoin, when you spend Bitcoin, what actually happens is this. You rarely move a Bitcoin as a whole coin, in a whole unit. What will happen is on your wallet, which isn't a store of coins, it's a store of private encryption keys, what actually happens is this. You have had maybe 10, 20 transactions that have collectively built up your digital coins in your wallet. You may own 20, 30, 40. They may have come from 20, 30, 40, 100 separate transactions. And then each of those will have come from another 20, 30, 40, 100 transactions. And the multiple small amounts of Bitcoin are effectively stuck together, aggregated to create your holding at any one point in time. And then when you transfer that, when you sell that on, what you do is you break a portion off, you put that in a new address, and you convey, move, transfer the private key that controls that address, but you then create a new separate identity area with the residual amount of the Bitcoins. So I quite like this idea of a digital data point. And that's going to be my provisional definition of certainly digital coins going forward and other digital assets. Now, still some other points to deal with. What are digital rights? As I see it, we can have 2 types of digital rights. We can have what I'm going to call origin rights, or rights that are created on a blockchain. But we're also going to have what we can call conversion rights. And conversion rights are where we take an existing ledger of any form. Could be mortgages, could be land, could be ships, cars, whatever, and we convert that over onto a blockchain of some form. I'm going to call them conversion rights. Now, the issue that then arises under law, if we have conversion rights, are we creating 2 parallel rights? Does one substitute, or does one replace the other, or do they exist in parallel? Do we have the right to the car, or do we have the right to the digital data point that holds the car? And again, there's some quite difficult law involved here. A lot of it will have to be dealt with under the terms of the system that we're setting up. The only problem there is the coders and a lot of the techies in this area, they don't want to use law. They don't want to use writing. They don't want to use terms and conditions. They want to deal with everything in code. And I'm going to come back and draw some conclusions on that at the end. Now also then, in terms of these different ledgers, what's the difference between a new distributed ledger and a more traditional land register or land record? Normally what happens is this: when you sell something, when you sell a car, when you sell a ship, when you sell a plane, when you sell land, the title moves under the contract, under the missives of sale, under the supporting documentation. And all that actually happens is the register becomes evidence. It's an evidential record of something, title that moved under a separate transaction. So most ledgers are actually evidential only. The distinction and the interesting point that arises in the digital area is that all of these new blockchains, they actually move the title directly, and the title cannot move otherwise than on the blockchain itself. There are no separate contracts, there are no separate missives, and the only way you can actually move, acquire, lose, destroy title is through adjusting the entry on the blockchain using the relevant public and private keys. So what I'm going to do is this: I'm going to distinguish ledgers in terms of new title ledgers and more traditional, what we can call record or evidential ledgers. And we have to do all of this just to understand all the basics which are actually happening in this area. Just on money and legal tender, all the new digital coins we're creating, are they money? Well, all the economists, they look at this and they say, well, they can discharge the same functions as money, therefore they must be money. From a legal perspective, I would say that's completely wrong, completely erroneous. Digital coins are not denominated in the form of an official currency, and they're not issued and used under the authority of the state. Therefore, I would argue in both cases they don't constitute money. The next question then is legal tender. If we create sovereign coin, state coin, which I've been working on with various central banks, do they become legal tender? Only if we extend the existing legal tender laws to include them. Now, there's a lot of difficult issues here then in terms of what is the nature of digital property going forward. Do we have any solutions? I've come up with 3 provisional solutions. What we can do is this: we need to either create a new form of intangible, movable, digital property under English law. We have shows in possession, which are physical, possessible, movable items, and we have claims. We need to create a large, substantial new area of immovable, intangible property under English law. Now, what we could do is either include that within shows in action, and I currently would argue, if I had to go to court, that's what I would argue as a barrister, and I think the courts would side with that. We would currently include new digital assets within shows in action as the residual area of English property law. However, what I would say is we actually need to create a new model in the middle. Now, there is actually a precedent for this, which is a patent under English law. Under all the early patent laws, a patent was always treated as a shows in action, because most intellectual property rights are included within shows in action, although they're not strictly claims, they're real rights. It's just that they're intangible rather than tangible. But what actually happened in the latest patent law, the draftsman actually changed the law, and he wrote, a patent shall be movable property, brackets, but not a thing in action, close brackets. And nobody knows why that was done. And I spent weeks up in Cambridge University Library looking at all the intellectual property rights, trying to find out why the draftsman of the last patent law did that. And eventually I found something with some references to the Hansard and the parliamentary statements which support this. And what he was trying to do was this: he was trying to do exactly what I'm suggesting we do now, to create a new form of intangible, movable property under English law. And the model for the idea of the patent, statutory patent right, was actually know-how. Because know-how is not physical, but it's actually still a very highly valuable commercial asset. And I think there's a clear precedent and a clear model there for including digital rights and dealing with digital rights in the same way. Secondly, the alternative to that is this: we develop a new doctrine of what I'm going to call constructive digital possession. How do you own a digital asset? How do you own a Bitcoin? Well, because it's got no physical reality, you can't. But I would actually say, if you control the private key, because of that control, that signifies ownership. Now, again, we have a model for this in the area of drugs. And what we do is this: we apply all of the drug trafficking laws to people, not that hold and own the drugs, but who actually control the distribution, allocation, use, protection, whatever. So we actually have a doctrine of constructive digital possession under English criminal law that we use in connection with drug trafficking. I think we could clearly, again, extend that in the digital area. If you control a digital asset through the private key, you own and control that, so therefore we could develop a new doctrine of constructive digital possession. The other idea would then simply be, let's create a new area of law. Let's create a new lex digitalis, or a new lex technologica digitalis, and I'll come back to this at the end. I think we will ultimately be doing this. The only problem is this: if we start to involve the government, and certainly if we start to involve authorities like the European Commission and the other European regulators, what will happen is they will inevitably over-regulate. And we'll have problems like we had with the BIT license in New York, and then all of the other restrictions and controls we saw on some of the earlier slides earlier. So I think to the extent we can, we should try and avoid new statutory intervention, new statutory forms of control, because governments will inevitably over-regulate. And that will then limit, destroy, prevent the growth in this highly exciting, new, innovative private market. So I would advocate we go for private solutions. So what I'm going to call this in Latin is lex digitalis privatis, or lex digitalis technologica privatis. We want private solutions, private law. Now, is there a model for that again? Well, yes, of course. The large international finance markets, the euro loan market, the euro dollar market, the international financial derivatives markets. How do they regulate? There's no agency big enough, there's no government large enough to regulate them. They regulate themselves. We do it through trade associations, we do it through standard documentation, we do it through private law. I think that's the model for this going forward. But as I've said before, there's a tension between the coders and the techies, because they think they can do everything through code. I don't think they can. What we need to have is a clear set of supporting rules, terms and conditions under which technology will work. We need to create a new relationship between code and law. And I'll come back to that in a couple of minutes. I'll just try and outline some of the other ideas. We've already heard some talk about digital identity. The point is this: almost everybody in this room has multiple identities. You all have digital identifiers, digital handles, digital what we call monikers, digital sobriquets, or digital pseudonyms. What are those? Those are all the nicknames you create for yourself on all the social media sites you go to. Everybody now has multiple identities. The only problem is this: what about if you want to create legal effect? Or what about if you create or you infringe some criminal law? What about legal liability? And we've come up with this rather difficult issue of identification. As far as I'm concerned, we shouldn't interfere with the right of people to create their own pseudonyms and to use their own sobriquets, handles, monikers, other identifiers on the system, except where there could be legal implications. In that case, we then need to have some form of identification. Now, we already have laws with digital signatures, and what I think we should do is simplify those and extend those. We already have digital signatures. We have simple and advanced under the EU Electronic Signature Directive 1999 and the UK Electronic Signatures Act 2000. What I would like to see is a lot more use of them. I talk to people and they don't know anything about it, they don't know how to use it, they don't know how to create it. What we need are new platforms that can easily allow us to use these digital signatures, so that where we want a document to have legal effect, we can do so. And then where in social media sites and all sorts of other areas, we just use and continue to have our own pseudonyms and other identifiers. We also then need to look at this idea of liability. Now, this is a difficult area. And what I thought was, I'll look at public international law, and then I'll look at private international law, and I'll be able to work out the answer. But what again I found out was this: there is nothing in the middle. Public international law deals with governments, public bodies, and their relations intersect. International private law is about dividing up domestic laws to deal with the allocation of a specific legal system to a particular point of whether it's contract, obligation, agency, tort, or whatever. So we have private law, and then we have public international law. What we do not have is this. We do not have an area of what I'm going to call international public law. Not public international law, but international public law. And what's this to do with? A lot of the most exciting, interesting cases recently on the internet include cases like Coble, Mark Coble versus Yahoo, Louis Theroux versus Viewfinder, Citroën and Zundel. And what are all these cases about? What they're about is this. People with platforms, with websites, infringe the criminal law in other countries. And the question simply is, to what extent can we enforce, on an extraterritorial basis, the criminal law from another state? That's what we're talking about here. And as I've said, I have to spend a little bit of time thinking about this. But what happens is this. We have a huge gap between public international law and then private international law. We need to create a whole new area of what I'm going to call international public law or public order law, which is essentially to do with where we can extend domestic, criminal, and other public administrative law jurisdiction beyond a single state. Now, on what basis could we do that? Normally, because of the idea of the exclusive territoriality and sovereign controls of sovereignty, you're normally limited to only being able to apply those kind of public laws within the territory of a particular state. But the point is this. Because of the virtual nature, online nature of the new digital systems we're creating and the internet specifically, it's very easy to breach the criminal law in another country. So is there a test? Is there a solution that could actually reconcile this? Well, I think there is, and it's called targeting theory. And what targeting theory means is this. If your website or your information or your statements or your promotions, your advertisements are targeted at residents in another state, you effectively invite, agree by implication, to become subject to the laws in that state. Now, it actually works the opposite. If you do not want to become subject to the criminal laws in America or Germany or whatever else, what you do is you make clear on your website or your promotions or your whatever else that you do not intend this to be accepted by, used by, acted on by people in another state. Now again, we do this all the time in international finance law. The Americans are very aggressive in having extraterritorial application of the Securities Act, the Securities Exchange Act, and we have to be very careful in our documentation that we exclude many of the things we do to be made available and purchased by American citizens. We can do exactly the same in the internet area. Now this is an important new field. There's very little, I think, being done on this, but we're going to need to look at this longer term going forward. If those of you don't know about this, I'll just mention the Coble and Yahoo case very, very quickly. What had happened was this. It was to do with the sale of Nazi memorabilia, which is criminal in France. So a French resident tried to have the French courts prohibit Yahoo from advertising the sale of Nazi memorabilia in France. Now Yahoo, France said, okay, we'll take it down, and they did that. But the action then went further. What the resident tried to do was enforce and get the French courts to enforce an order against Yahoo America to prohibit the sale and advertising of this all around the world. And this raises very difficult areas of law. What then happened was Yahoo went back to America and then applied to the courts in America and tried to have an action to dismiss this and to confirm that it had the right to advertise this and sell this at least outside France. This raises some very difficult issues, and we don't know the answer yet. I personally think it's quite simple. We develop this doctrine of targeting theory. But again, what then effectively happens is this. We're creating a whole new area of law. This idea of international public law, public order law, between public international law and between private international law. We also need to develop a whole new series of new systems for cross-border resolution and enforcement. I look at this in my paper. I'm going to refer to it in terms of digital dispute resolution, DDR, instead of ADR, or technological dispute resolution, TDR. Now, there's a lot we can say on risk. I'll come back to that. Everybody talks about FinTech and RegTech. I'm already extending that. I'm going to have FinRisk, I'm going to have FinReg, I'm going to have RegTech, not just TechReg, and look at all of this. I'm going to have MacroTech, RegTech, ResTech, SuperTech, SupTech, everything. and it's all in the paper. I'll come back to that. I haven't got much time. International public law. Let me come on to this very quickly. I want to make 3 points here. Again, we're going through a very interesting phase, very interesting area. I've already mentioned Peter Drahos. I've already mentioned Scottish philosopher James Boyle. There's also Lawrence Lessig, professor at Harvard. He's also been looking at this and writing about what we now call the new code world. And he had a famous book called Code 1.0, and then there's now a new one, I think it's Code 2.0, which are available on the internet, on open source software. And what Lessig is looking at is this idea of we're actually going to replace traditional legal systems with code. And what are the implications of that? Lessig describes society as being governed by various things, norms and culture and law and code. I take that and I restate it, and I say that society going forward will be governed and regulated and controlled by commerce, culture, contract, courts, and code. 5 C's. The problem is we need to get the relationship right between law and code. What the coders want to do, what the techies want to do, is basically replace all law, and that's what smart contracts are for. I don't think it can be done. We're always going to have to protect rights. We always need to respect and look after private rights. There's always going to be disputes. Not within the Bitcoin chain itself, not within Ethereum itself, not within Darkcoin or any other coin itself, not within all the new smart contracts themselves, but when we use these in the real world with regards to other things. We're always going to need to protect people's rights. There's always going to be legal rights and obligations that we need to respect. So what I'm saying is this: we need to create a new relationship between code and law. And if we do that right, and if we do it intelligently, and as I said before, my principal recommendation would be, let's do it through private law. Let's do it through documentation, standard documentation. Then we can avoid heavy state government control, heavy new regulatory law. And I'm going to call this, as I've said before, Lex Digitalis. We talk about the Lex Lata is the law as it is, and we talk about the Lex Ferranda is the law in the future. So my Lex Ferranda is going to be Digitalis, Technologica, Privatus, to avoid a lot of heavy regulation. Now, just one other, I've got a couple of minutes, just on international private law. I'm very fortunate to have been invited to become a member of the Financial Markets Law Committee Working Group on Digital Currencies. And in connection with that, I came up with a number of ideas to try and deal with this idea of digital location. Where is a Bitcoin? Where is Ether at any one point in time? Where is any other digital asset that's created and held on a blockchain all around the world? Where is it at any point in time? Well, basically it's everywhere, because the nodes are everywhere and the programs are everywhere. So we have no concept of location when we look at digital assets. But as I've already explained, we may transfer all of the current financial assets in the world to these new digital ledgers within the next 5 to 10 to 20 years. We will transfer, we will create 225 trillion, a quarter of a quadrillion new digital assets, which we can't classify under law, we can't define under law, they're based on information and we don't know what that is in law, and we also can't locate. So again, I came up with that series of solutions. We have what's called the doctrine of Prima. Prima is the primary residence of the intermediary account. And we use that in connection with the law of securities and global custody. And this was developed at the international level to try and locate securities held in electronic payment systems. So Prima is an existing doctrine that applies. So I take this idea and develop it. They've already extended that to include what we call Prima Plus. And Prima Plus is a form of elective contractual jurisdiction. So the parties to a payment and clearing system for a specific type of derivative, government contract or security will say, we agree that this shall be governed by English law and that the English court shall have jurisdiction. So we call that Prima Plus because it's a form of elective agreed jurisdiction. So what I then say is this: well, why don't we have Prima Direct, Prima Minus, Propa, Prama, and Prema? So I take the same little idea and then I extend it. And what do I mean by all of those? Prima Direct is where the issuer of a digital security, where is the company located? So I'm going to call that Prima Direct. Prima Direct is where digital securities are issued by a company. You look at the head office, where is the company located? We'll then get Prima Minus. Prima Minus is where the parties don't elect and decide, but the authorities decide. So the Financial Conduct Authority in this country decides that for the purposes of this new clearing system in connection with this, we will deem this to be based in London. So if there's no Prima and there's no Prima Plus, which is elected jurisdiction, I will allow for either Prima Minus or Prima Direct. What we can then also have is this. We can look at who's the operating authority or who's the operator, and that would be Prima, or who is the coder or the original manufacturer, and that would be Proma. And then ultimately, if all of this doesn't work, what's the default position going to be? Again, coming back to the idea I said before, what's the closest thing we have to identifying control and locating control? It's where the private encryption key is held. So I'm going to call that Prima, the primary residence of the encryption master key account, Prima. Now there are some problems in this because, for example, private keys can be held by machines, and machines can trade with other machines and deal with other machines. We'll have to have special rules for that. I personally would exclude the machines. If it's a machine, it's whoever instructed the machine or whoever's controlling the machine. There would then be other situations like employer, employee, principal, agent. In these situations, I would just apply existing law to work out who's controlling it, who's locating it. But I think we can solve all of these problems. The biggest problem is the fact that no one's actually raising these issues just now. Going back to the core law, the core problems, the core issues. And I think with this framework, we can begin to do that. Now, just to close again, let me just say, what I was going to do is look at risk and regulation, and then the last crisis, extend that into the next crisis, and then solve it by applying similar solutions. But we'll come back to that at another time. I just want to close by getting back to the point I made before. I think we have to create a new relationship between law and code. This area is going to be enormously exciting. Just in terms of the extensions, what have we got? We've already got digital coin, private digital coin. Then we're going to have sovereign coin very quickly. After that, what are we going to do? We're going to convert lots of other asset registers into a digital form. All the land registers, all the car registers, shipping, aircraft, everything is all going to be transferred. After that, what are we going to have? Any form of creative input of any type can be immediately time-stamped and hashed and stored on a ledger. But what we've also got is this. We've got it to create an immutable record. But what we're also going to do is, and we have websites already providing these services, we can use distributed ledgers for information purposes, information storage and publication. We can use them for digital personnel. In future, passports, inland revenue systems, welfare systems, all sorts of forms of personal identity can all be held on digital ledgers because of the immutability of the system. But we've also got smart contracts, as we've already discussed before. Smart contracts, as far as we can, what will happen over the next 5 to 10 years, we're going to code virtually everything. There will be a lot of unemployment because of this, and I'll come back to that if there's time, maybe in questions later. So smart contracts, but also regulatory purposes and RegTech. We're going to use distributed ledgers for recording and regulatory compliance and reporting purposes. And then the 8th extension, possibly the most exciting of all, is going to be decision-taking, management and social organization. We already have DAOs, decentralized autonomous organizations. In future, we're going to have DACs and DASs, decentralized autonomous communities, and then decentralized autonomous societies. To a large extent, what we will do is all forms of decision-taking, governance, management can all be turned into an automated, digitalized smart form. And as I've said before, and I'll conclude on this, what I think we need to do is this, and this is the key recommendation. We need to create a new relationship between law and code. As I've said before, extending Lessig at Harvard, I think society is going to be governed by commerce, culture, contract, courts in emergency situations, and code. But what we need to do is this: we need to preempt a lot of heavy government regulation. If we can do it through private documentation, private systems, I think that's the solution. And this could be very exciting, very fast area, very fast growing area. Law, technology, and social